The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon, everyone. The next case is the Cherry Community Organization et al. Versus Sellars et al., and we will hear from the appellant.
Good afternoon, Your Honors. May it please the court. I'm Carrie Shadd, and with my colleague Scott Muskimen, we represent the appellant, the Cherry Community Organization, in this matter. Your Honors, this is a creditor's rights case involving actual fraud. Resolution of the case has very significant implications for business in North Carolina. If the decision of the trial court and the Court of Appeals stands, not only will that change the law, but there will now exist in North Carolina a perfect roadmap for how to cheat creditors and for how recipients of fraudulent transfers can just simply close their eyes to what is right in front of them and keep the benefit of their partner's actual fraud. The legal issue in the case is whether MAP, transferee, established that it was a good faith purchaser under the Act. And if so, it's entitled to keep the land that was fraudulently transferred to it by its joint venture partner, Stone Hunt. Your Honors, respectfully, the answer to whether MAP was a good faith purchaser is absolutely not. And there are two separate reasons for that. I'm going to take the first 10 minutes.
Before you get into the good faith purchaser, am I correct in understanding that you all concede that there was fair market value given for the property, the $1.1 million?
Yes, sir. That is not an issue in this appeal.
Okay, so really what we're confronted with is a debtor who conveys property for value, and the question is, does the recipient, who may have known of some of the circumstances that you've described as actual fraudulence, with that actual knowledge, does that bring it under the statute?
Well, actually, it's a little more nuanced than that, Judge Newby. So the first issue, and the issue that I'm going to take up, is whether under basic agency law, the fact that Stone Hunt, the transferor, and MAP, the transferee, were joint venturers together for the purpose of developing the subject property into a mixed-use big project, whether that fact and the fact that they were found to be de facto partners by the trial court means that Stone Hunt's knowledge of its own actual fraud intent, its own bad intent, is imputed to its business partner, the transferee. That's the issue that I'm going to address. And the answer under clear law is that yes, Stone Hunt's knowledge of its own actual intent is imputed. It doesn't matter under this theory whether MAP had any actual fraudulent intent of its own. It doesn't matter whether MAP actually knew of Stone Hunt's fraudulent intent. It is imputed by operation of law as a direct result of the fact of the joint venture and the fact of the de facto partnership, both of which were found by the trial court, accepted by the Court of Appeals, and not challenged on appeal by MAP. MAP did not object to any of the findings of fact. MAP did not cross appeal. It is bound by the findings of fact in this case. Mr. Muskimen will take up the standard involving suspicious circumstances and the duty to inquire in his 15 minutes. But I'm going to take the rest of 10, and he's going to take 15, and we have 5 for rebuttal. As I said, the Court of Appeals stated the law regarding agency correctly. MAP and Stone Hunt were members of a partnership that existed for the purpose of developing subject property and other parcels. Where the Court of Appeals erred was, instead of imputing Stone Hunt's knowledge, which is what the law requires, it relied inappropriately on what's called the adverse interest exception to avoid imputation. Now, MAP doesn't challenge anything about agency law. MAP doesn't even discuss the adverse interest exception in its briefing. Instead, what it wants to do is attack the trial court's findings that a joint venture relationship and the de facto partnership existed in the first place, and that there were actions taken in furtherance of that relationship. And those are findings of fact 19, 38, 39, 40, 43, 47, and conclusion of law 12. But again, MAP did not challenge those findings, and they are bound by those findings on appeal. Even if the trial court hadn't found those as facts, MAP made binding judicial admissions through its answers in this case. It answered multiple paragraphs in our verified complaint, paragraphs 19, 30, 34 to 40, 43, and 45 of our verified complaint, which is in the record. It admitted all of those paragraphs, and all of those paragraphs allege the existence of the joint venture and allege the conduct of activities in furtherance of the joint venture. The answers appear in the record at 174 and 249 and subsequent pages to each of those. They are bound by their admissions in their answer. They are bound by the findings of fact. There were other admissions of the joint venture. Mr. Good, the principal of MAP, submitted an affidavit to the Court of Appeals in the first lawsuit that CCO brought against Stonehunt and got the verdict, describing the relationship as a joint venture. He testified under oath and deposition that there was a joint venture for the purpose of developing the project. At trial, Mr. Good testified that there was a joint venture. It's in the transcript at 953, 968, 991, 1016, 1017, 1026. Even in their brief to this court, MAP actually cites to the conclusion of law that states, quote, as joint venturers in an unincorporated entity, MAP and Stonehunt operated as a de facto general partnership. MAP cites to that conclusion of law, which I think is actually a finding of fact, and then says at page 21 of its brief that that conclusion is fully supported by the record in this case. So it is beyond challenge that MAP and Stonehunt were in a joint venture relationship in connection with this subject property. And regarding a de facto partnership, existence of such a partnership is a finding of fact. The Best Cartage case, actually cited by MAP, makes that point and refers to this court's decision in Potter. And the trial court found that a de facto partnership did exist. And in finding of fact 43, the court found that the relationship between the two, the ongoing relationship and the mutual trust that was established as business partners, that is the quote, was the critical ingredient in allowing Stonehunt to get rid of the property quickly, cash out, not advertise it, keep it a secret from CCO. And there was a finding of fact that MAP and CCO agreed to keep it quiet until it was too late. And MAP did not challenge any of those findings of fact. That's finding of fact 53. And MAP tries to avoid the consequences of all of this by coming up with this limited insider theory, which is a fiction and has no support in the law whatsoever. So MAP is essentially asking this court to carve out some special category of limited insider that is not discussed in the statute and is not supported in the case law. Accept that we have a joint venture and a de facto partnership. The rest is easy. General agency principles apply. Those principles include that each member of a joint venture is an agent for the co-venturer and a principal for himself. General partner is the agent for all other partners. Notice to the agent is notice to the principal. As a result,
Ms. Shad, just so I can follow your argument here, assuming that we were to accept your argument to this point under the Uniform Avoidable Transfers Act, and I'll say that wrong about 3 times before we get finished. What does that do for your position as you understand it?
We win, Judge, we win. What it means is,
if we were to agree with you on this point, then there's no need for any further inquiry at all.
correct.
Okay.
That's absolutely correct.
And that would be because the intent of Stonehunt through Mr. Sellars would be deemed to be the intent of MAP.
Actually, it's a little different, Judge. It is the
Okay.
knowledge, it is the knowledge of Mr. Sellers for Stone Hunt, the knowledge of his own and Stone Hunt's own intent to defraud. That knowledge is what is imputed and becomes the knowledge of the transferee. And with that knowledge of fraudulent intent, they cannot, as a matter of law, be good faith purchasers. Cannot. My 10 minutes, and I'm going, unless there are further questions, I'm going to move aside and let Mr. Muskimen pick up with his argument.
Good afternoon, and may it please the court. My name is Scott Muskimen, and I'm with the Smith Anderson Law Firm and represent the plaintiff appellant, the Cherry Community Organization. And besides the points that Ms. Shad just made, the Court of Appeals should be reversed for a number of additional reasons. First and foremost, the Court of Appeals applied the wrong legal standard on the defense of good faith that the appellees had the burden of proof on. The decision below is contrary to a number of decisions rendered by this court. The trial court applied a different legal standard. That standard was also the wrong legal standard. Had both of the courts below applied the correct legal standard to the undisputed and admitted facts of this case, then those courts would have ruled that MAP failed to meet its burden of proof on its affirmative defense of good faith. By reversing the courts below, that will allow this court to bring forward this court's own body of case law developed in the late 1800s, early 1900s, and modernize fraudulent transfer law. And it will give meaning and clarity to an important term under the Uniform Voidable Transactions Act that is not specifically defined. Reversing the courts below will also advance the General Assembly's mandate to make our statute, our case law under the Uniform Act, uniform with the law of those other states that have also enacted the Uniform Act. And reversing the courts below will also allow this court to rule unequivocally that when a transferee fails to purchase in good faith, that transferee has violated the North Carolina Unfair or Deceptive Trade Practices Act. As Ms. Shad said, this case is about creditors' rights. CCO is creditor of Stone Hunt. Stone Hunt had the actual intent to defraud its creditors, including CCO, and it transferred its last substantial assets to its business partner, MAP. That's undisputed in this case. Those are the findings of fact and the conclusions. And MAP does not challenge that on appeal. It is unequivocal that Stone Hunt had that actual intent to defraud CCO and did defraud CCO. The undisputed facts show that MAP purchased with notice of suspicious circumstances, which then triggered a duty that MAP had to investigate. But there is no evidence in the record that MAP investigated. Instead, MAP's admissions at trial show that MAP turned a blind eye and adopted a strategy of willful ignorance. And because of that, under our law, MAP did not and cannot meet its burden of proof as to good faith. Therefore, the Court of Appeals should be reversed and the deed to MAP should be voided. The Uniform Act was fairly recently enacted by the North Carolina General Assembly, and it outlines various claims and defenses. This is an actual fraud case, and the defense to actual fraud under the Act is proving two elements. One is good faith, and one is proving reasonably equivalent value. And MAP, under the Act, has the burden of proof as to both of those elements. And if it doesn't prove both, if it only proves one, then MAP still loses. The transferee loses, the transaction is voided, and the property comes back to provide assets to satisfy or partially satisfy the creditor's judgment. The Uniform Act does not define.
Are you arguing that good faith is a question of law, or is it a question of fact?
So good faith is a conclusion of law. And it's a conclusion of law because it's an affirmative defense under the statute. And that affirmative defense determines whether or not the defendant transferee is liable to the plaintiff creditor. It involves not only the determination of liability, but it involves the application of legal principles, here the correct legal standard, to the facts. And it's a classic conclusion of law. We cite to the this court's recent case in State versus Parisi, in which the court discussed what's the conclusion of law and what's a finding of fact. And where the liability is determined, where the conclusion of law states the legal basis upon which a defense liability may be predicated under the applicable statutes, it's a conclusion of law. That's the case with good faith. Transferee is or is not liable under the statute, depending upon whether the transferee has liability. It involves the application of legal principles to the facts. Here, the correct legal standard, which was not applied by either of the courts below.
Well, and let's talk about that a little bit. The term good faith it appears in GS 39-23.8 is not defined in the statute that I could find. Am I missing something, or is that right?
That is correct. And what the statute says in the comment is that good faith is consistent with prior law. So that then puts it upon us to look at the case law that's been developed by this court as to what good faith is and is not.
It appears to me that your colleagues are arguing, in effect, that MAP, faced the situation that it faced. It didn't intend to defraud anybody, that it did what any reasonable developer would do under the circumstances that it faced. Therefore, it acted in good faith. I mean, that seems to be the argument. Assuming that I have not mischaracterized the argument, why is that not a valid description of good faith?
Because that's not the correct legal standard, first. And second, what we know from cases from this court that we have cited in our brief is that the transferee's intent is not relevant. We've cited to the cases of Henry W. Wolf versus Arthur. We've cited to Kanzler versus Cobb and Wright versus Cotton. And all those cases say that you don't look into the transferee's subjective intent. Instead, it's an objective standard. That standard has been articulated in a number of cases from this court. It's a notice standard. And for example, under the Henry W. Wolf case from this court, the standard is notice. If the transferee has notice of such facts as would induce any prudent man to institute and prosecute inquiries that would have led to the discovery of the fraudulent intent. That's consistent with the standard articulated by this court in Bryan versus Hodges, as well as in Wilson versus Taylor. So the question then becomes, if the transferee has notice of the suspicious circumstances, also called badges of fraud or red flags, then that triggers a duty to conduct a diligent investigation that would have led to the discovery of the transferor's fraudulent intent. If there is no diligent investigation, then the transferee loses. The transferee cannot stand idly by, stick its head in the sand, and ignore those suspicious circumstances. If they know of suspicious circumstances, there's the duty to conduct the diligent investigation. And that does not involve just simply accepting the story being told by the transferor. This court in Bryan versus Hodges said that that is improper to do that. If the transferee fails to conduct the investigation, this court said in the Wilson case, the transferee is chargeable with all knowledge he would have acquired if he had made the necessary effort to discover the truth. And in this case, we have a plethora of admitted and undisputed facts in the record, a robust record that shows that MAP was on notice of numerous suspicious circumstances. In pages 54 to 58 of CCO's principal brief, we lay out a host of suspicious circumstances. I won't go through them all, just let me hit the highlights for a moment. We know that MAP knew that Stonehunt had been sued. MAP had a copy of CCO's lawsuit on the day it was filed. MAP knew that it was purchasing from its own business partner. Therefore, MAP knew it was purchasing from an insider. MAP knew that Stonehunt, its business partner, was getting out of the real estate development business. CCO, in writing, warned MAP months before the transaction, do not purchase the property. And said in that letter, if you purchase the property, parcel A that's part of the subject property, if you purchase, you do so at your own risk and peril. The purchase contract that was done between MAP and Stonehunt was done on a hurry-up basis. It was discussed in September of 2016, and then the actual contract was done on a hurry-up basis 3 months later in December of 2016, after the Court of Appeals heard oral argument on CCO's appeal in the first lawsuit. And litigation counsel for Stonehunt sent the warning email to MAP's attorneys saying, we're going to get a ruling very soon from the Court of Appeals. We advise you to get this done as soon as possible. So it was done on a hurry-up basis. The contract was done within about a week after that warning email. And then MAP closed on the purchase in early February of 2017 after it knew that the Court of Appeals had reinstated CCO's claims. So those claims had been tested on appeal and found to have merit. They were reinstated, and MAP knew all of that. MAP was working on a workaround to get it done before the Court of Appeals ruled. They didn't get the transaction done until after the Court of Appeals had actually ruled. And
What impact should it have on a buyer of real estate when there's no longer a list pendants? In other words, the title to the property is no longer encumbered.
Well, that's not a relevant factor. That's not part of the correct legal standard. It has nothing to do with the duty to investigate in the face of suspicious circumstances. It has nothing to do with remaining willfully ignorant, as MAP was. Instead, the list pendants argument is the argument that MAP has been hitting hard since the early days of this case. It's a red herring. It doesn't matter, because in order for a creditor like CCO to set aside a fraudulent transfer, the creditor does not have to have a claim on the title to the asset. Under the statute, there's no linkage between claim and asset. All assets that are fraudulently transferred can come back to satisfy creditors' claims. That's important for protecting creditors. Can you imagine, say you're with Bank of America or Wells Fargo or First Citizens, and you get a ruling from this court saying, well, you know, if you don't have a claim to the title of the asset, then your debtor can fraudulently transfer unencumbered assets. So if you say, as a creditor, sees collateral that partially satisfies the judgment, you're now unsecured. You're a deficiency creditor. Your debtor's you've got a deficiency judgment against that debtor. Well, sorry, you're out of luck. Under that theory, all deficiency judgments will no longer be collected or collectible under that theory. If the bankers
Not if you're getting fair market value. I mean, the claim then goes to the funds that were received in lieu of the real estate.
A creditor like CCO who has a claim for $7 million and have a deficiency judgment, you would be able to go against some assets that would get pulled back. But under this theory that MAP has been promoting, assets that are not tied to the claim would be protected through fraud, that the judgment debtor would get a free pass on a fraudulent transfer. That can't be our
How are they protected when you're getting fair market value? I mean, okay, I've got real estate. Now I have $200,000 plus a $900,000 promissory note. How is that being defrauded when you still have the value?
Well, there is that value, but then there are these other assets that get fraudulently transferred that were not, say tied to the creditor's claim. Those assets could come and should come back to satisfy the creditor's judgments. You may have a multi-million-dollar personal injury claim. Well, that tort claimant will never have a claim on the assets. Are we really going to have a rule that says that tort claimants will never be able to collect their judgments because they didn't have a claim to the title of the assets? No, of course not. That can't be.
We seem to be missing each other. Real estate is worth $1.1 million. It's not the land, it's the value. Now, you change that to $1.1 million. How is the creditor being defrauded if on the one hand, your claim was against land and now your claim is against the $1.1 million that is the equivalent value of the land?
So in this case, CCO had a claim to get the land because the units of housing were supposed to be built on that land, and that was taken away through this fraudulent transfer. CCO was trying to get that land back so that it can utilize land, which is unique, in this neighborhood for the construction of these affordable housing units.
Well, if that's true, that's what list pendants are all about. We're saying that this land is so unique in character that it's subject to the pending litigation.
There is no case law from this court that says that that is the correct legal standard. We know what the correct legal standard is. It's a notice standard, notice of suspicious circumstances, and the duty to investigate. It's undisputed that MAP chose not to investigate. It admitted repeatedly that it had no interest in finding out anything about Stonehunt's business or the litigation. Instead, it turned a blind eye as a matter of law. That is not good faith. That is bad faith. And
I apologize for taking you in your rebuttal time.
Thank you. I believe we've reserved a few more minutes, and I think we have about 3.5 minutes left for rebuttal.
Correct. Thank you.
Okay, thank you.
We'll hear from the appellee.
May it please the court, my name's Roy Michaud. I'm with Alexander Ricks in Charlotte. Matt Houston and I have represented the MAP entities in connection with the Voidable Transfer action. I have represented the MAP entities from the very beginning in both the rezoning challenge and in this action. And I hope by the end of the day that you all will agree with Judge Levinson that MAP has done absolutely nothing wrong in this transaction. There was a joint venture solely for the purpose of applying to the city council for a change in zoning on this property. That is a venture for profit that two people entered into. That, in the broad sense of the word, it makes both parties insiders. And Judge Levinson found that there was a joint venture for the sole purpose of applying for a rezoning. Now, once the rezoning was applied for, after numerous meetings with the CCO and other people in the community, there was a public hearing before the city council in April of 2015. After all of these meetings and 11 days before a decision meeting that was scheduled in September of 2015, MAP learned of this claim by the CCO after it had spent some $130,000 in connection with a rezoning. 3 weeks later, the CCO files a challenge to the decision of the city council on September 27 to grant the rezoning. A challenge that had absolutely no merit and no chance of success, and was filed solely to tie up the title to this 0.78 acres until the CCO could attempt to perfect a judgment and then proceed against the property. There are several milestones that have occurred from and after the institution of these two lawsuits. The first was that in September of 2016, while the case, the underlying case filed by the CCO was on appeal, Stony Sellars comes to MAP and says, I no longer want to be in the real estate business. I have a son who has autism. I have another business that I want to support. I want to sell this property. That was in September of 17. Those negotiations lasted for over 4 months. And in December of 2016, the Court of Appeals reversed a 12B6 motion to dismiss the CCO's lawsuit, assuming under the rule that all of the allegations in the complaint are taken as true. There's nothing about that decision that in any way puts MAP or anybody else on notice of anything other than the fact that the CCO has a claim that passed the 12B6 dismissal.
Was MAP obligated to accept defendant Sellers' representation at face value that he was getting out of the real estate business for that reason?
Well, I don't know that it was that reason. You see, if you put this in the right perspective, Stone Hunt had sold most of its properties back in 2014 with no issue whatsoever after a rezoning that showed that those properties would have 6 affordable housing units. There was no lawsuit filed at all about that. That sale went through. Stone Hunt had 0.78 acres, and that's all they had in this community. Now, I think they did own some apartment units, and maybe in Wake County. We don't know much about Stone Hunt's business because we were never involved in their business. But it was clear, as Judge Levinson noted, MAP was carrying the ball. It handled the rezoning. It paid all of the expenses. It carried out the defense of the challenge to the rezoning. Stone Hunt was not even made a party to the rezoning challenge. MAP covered all of the expense to defend that and to pursue it with no contribution whatsoever from Stone Hunt.
What's your response to the,
Stone Hunt was a passive investor, completely a passive investor. To my knowledge, they were not even in business in 2016, in December of 2016. They sold everything.
With regard to that passivity, what's your response to the other side's position that there could not be a convenient burial of the head in the sand in light of what you represent to be what was said to your client, that there was a desire to get out of the real estate business coupled with the other aspects that have been presented here as to badges of fraud?
Well, I'm gonna address that. That's a very legitimate question and a good one. As of February of 2017, when this sale occurred, there were really no badges of fraud to speak of. What did we know? Well, we knew that MAP had sold, that Stone Hunt had sold property for close to $3 million. It didn't have any business obligations except to defend this lawsuit that had been brought by the CCO. We knew that MAP had been given $200,000 in cash and a promissory note for $900,000 with a side agreement that if they settled their disputes with the CCO, that $900,000 would be paid earlier. There was no reason to believe in any way whatsoever that Stone Hunt was in any way insolvent. The evidence before us at the time was they had plenty of money. Now, one of the other
Mr. Michaud, let's go back to one of your earlier, took me a minute to find this in the order, and I was going to ask you about it anyway, but you had described the joint venture that the trial court found to exist between Stone Hunt and your client as solely relating to rezoning.
That's correct.
If you look at findings of fact 38, 39, and 40, 38 says at the time Stone Hunt transferred the subject property to MAP. MAP was an insider only to the extent that the two entities were cooperating and memorializing their intents, intentions, and writing with an end toward creating Baxter Place. Number 39 says principals, among other things, principals in each entity were naturally engaged with one another on occasional needs relating to the project. However, the real party driving the day-to-day effort to make Baxter Place come to fruition was MAP. During this time period, Stone Hunt and MAP acted in furtherance of their joint venture by each taking actions to develop the subject property owned by Stone Hunt and adjoining land owned by MAP into a planned $50 million mixed-use development that would be called Baxter Place. It looks to me as if those findings suggest that the joint venture was to develop Baxter Place, not just to obtain rezonings. Obviously, you don't agree with that, so tell me why.
No, I think that there's an explanation for that. What happened is that they each applied for the rezoning. They also entered into an operating agreement to specify and lay out their respective interests and obligations upon the approval of the rezoning and obtaining an anchor tenant. Those things never happened.
Is any of what you're telling me in the trial court's findings of fact?
I'd have to go back and look, Your Honor. It's a long judgment.
It's a long order, and that's why it took me a minute to find the part I was looking for. I understand the problem.
But the operating agreement, without question, was terminated at the time of this transfer. And another one of the milestones is that after this lawsuit was filed in August of 2017, there was a request for a preliminary injunction to keep MAP from making the payment. There was a hearing with Judge Levinson in Winston-Salem in January of 2018 before the payment was due, in an attempt by the CCO to avoid the money being paid to Stone Hunt. Judge Levinson denied that preliminary injunction after finding that he was not convinced that that CCO could prevail on the merits or that there was any irreparable harm. So he denied the injunction, and only after his denial did MAP make the $900,000 payment. They didn't do anything voluntarily. And
let me get to one other question while we're at it. If I'm understanding the argument that you've made in your brief and also the argument that you're making today, it seems to me that you're arguing in essence that it is sufficient to support a finding of good faith if a party acted in a commercially reasonable fashion, regardless of, based upon its own interest, regardless of what it may know about or not know about other people. Mr. McKimmon is arguing, on the other hand, that the test is something very different than that. He's argued, in effect, that if, under our case law, that if certain badges of fraud, is the expression that he's used, exist, and you then know that those badges of fraud are there and don't conduct any investigation into it, regardless of what you may or may not have actually known or actually intended, you are still liable under the Voidable Transactions Act. So that's a pretty dramatic difference in the view of the applicable law. Tell me why your view is right.
That's not really our argument. No,
Okay, well then, what is your argument?
I readily recognize that if somebody has inside information where they are on suspicion or knowledge that somebody has committed a fraud, that obviously that's not a defense. The badges of fraud exist and you can't ignore them. My argument in this case is that by virtue of this joint venture to rezone a piece of property, there is no agency or no other relationship between MAP and Stone Hunt that would impute fraud to MAP.
All right, so let me, before you go,
doesn't exist. It's not there.
before you go further, assuming for purposes of discussion that we did not accept your argument that the joint venture was limited to solely seeking a rezoning of the property, that instead the joint venture included proceeding to try to develop it as well, does your argument still work?
It does.
Tell me why.
Well, if you look at the cases that are cited for the badges of fraud, in every single instance, there is inside information by either the grantee of the property or grantee of the money in every single instance. In every one of those, the recipient of the property, one was a father who got money from his son who was in bankruptcy. The father and the son were one and the same because he handled all the father's business. The insider information in the oldest case that was cited was the daughter who took a deed from her father for services rendered. She never admitted that she did not know he was insolvent. He had multiple creditors. And in that case, it was a reversal on the charge to the jury. The other cases are the same way. In every instance, there was some inside information to the grantee that there was something amiss. You don't have that here, not at all.
Can I ask you about that point, about whether or not we have that here? Because I'm trying to then understand what you would have us make of finding of fact 47, where the trial court says, because of the joint venture between Stone Hunt and MAP, at the time of the transfer of the subject property to MAP, MAP was an insider of Stone Hunt within the meaning of the law. Aren't we bound by that finding of fact?
Well, they were an insider. They had a joint venture to do the rezoning. And I thought that Judge Levinson clarified that by his findings of fact, where he said that this joint venture was solely for a rezoning. They were insiders solely for the rezoning. He clarified that. I mean, we didn't have to challenge all of those. Judge Levinson made it clear. And one of the other milestones that I wanted to mention is that in June of 2018, Judge Levinson spent 3 weeks in a jury trial in the Stone Hunt CCO lawsuit. He then spent 9 days in a bench trial on the avoidable transfer. He knew everything there was to know about this case, everything. And after Stone Hunt filed bankruptcy, he was then allowed to issue his decisions in both cases. And he found, and I think properly so, that MAP was a bona fide purchaser for a reasonable value. And I submit to you that that decision is supported by the facts. It was upheld by the Court of Appeals, and it should be upheld by this court. And one last point about the notice of list pendants and the letter. Mr. Miskimmon says, oh, well, I wrote this letter in July of 2014 and told them that we had all these great claims. What did we know? We knew at that time that the letter lacked a lot of credibility. Number one, there was no notice of list pendants. It was gone. Number two, they had filed a almost spurious lawsuit that lasted for 30 months in which they challenged the rezoning of this property. 30 months. And so the third element was, oh, well, we got all these damages for construction. Well, the Cherry Gardens Apartments was built on property owned by Stonehunt. That property was transferred to a nonprofit LLC, which then procured a loan from Bank of America, built the Cherry Apartments, and that LLC owns it, operates it, collects the rents, and the Cherry Community Organization has absolutely nothing to do with it. It's an affordable housing apartment building that was caused to be created by Stonehunt. CCO doesn't own it, doesn't manage it, doesn't have anything to do with it. But yet, Mr. Miskimmon says, well, you know, they're obligated to build this for us too. And that's just not consistent with what had happened. So the letter itself is a lot of puffing. I think we would all agree to that. And when you add the badges of fraud, they just don't meet the test. And with that, I'll turn it over to Matt, unless there are other questions. Thank you.
Thank you. And may it please the court, my name is Matthew Houston of K&L Gates for the MAP entities. And I will largely handle the unfair and deceptive trade practices claim. But there are a couple of points that I think, touching on what Mr. Michaud had, and a couple of questions that you asked Justice Irvin and Justice Earls. One thing I want to point out is that regardless of the scope of this joint venture, we've noted that it was a limited scope. Regardless of that scope, Judge Levinson recognized in his finding of fact 45 that this transfer, and I quote, was not, and I quote, in furtherance of the party's business interests. And that's finding of fact 45. Judge Levinson said that the transfer was not a transfer done in furtherance of the party's business venture. So regardless of
Mr. Houston, to follow up on that a second, that the full finding says, quote, Stonehunt's transfer of the subject property was not a transfer done in furtherance of the party's business venture, which would be a little bit, my editorial comment would be, once you sell off the property that you're trying to develop, it's a little hard to say you're both going to go forward with it. Then says, instead, Stonehunt and MAP abandoned their joint venture and had it dissolved the same day as the February 2nd, 2017 closing. I guess I want to ask you the same question that I asked Mr. Michaud. Is there any specific finding in the trial court's order that says that the joint venture was limited to rezoning?
So that says specifically that it was only limited to rezoning.
Yes.
I would defer to the record, Your Honor. I do know that findings of fact, I believe it's 39 through 47, 38 or 39 through 47.
So if there is such a thing, it's in those findings somewhere?
Well, those specifically address the scope of it, but there are also conclusions of law and findings of fact throughout that discuss the scope of the joint venture. And the Judge Levinson did specifically address the rezoning. I don't know if he specifically said in the context it is only rezoning, but he did limit the scope to the rezoning and the party's business ventures. And so I want to point out that, as I said, finding of fact 45 does specifically say that the transfer of the property, which is at issue here, wasn't part of that business venture or that joint venture.
The business venture ended when the transfer occurred.
The business venture did end then, but regardless, the transfer itself was not within the scope of it, and he made that clear. And the trial judge would be entitled to deference in finding what the scope of that venture was, Your Honor. But to jump back,
can I just follow up on that? So, but why would that change the analysis of what of whether or not whether they were partners, whether or not there was a agency relationship, whether or not knowledge of one should be imputed to the other. They were in the joint venture way up until that day. Why wouldn't all the knowledge he had up until that day be imputed to his partner?
Sure, and that's a fairly easy answer, Your Honor. If you look at the Restatement Third of Agency, Section 5.03, Comment B, and that section is cited in CCO's brief, that section specifically notes that any imputation of knowledge must be within the scope of the party's relationship. And so you can't impute knowledge that isn't within the scope of the party's relationship. Here, the relationship, as we said, was a limited joint venture to the rezoning and the other points that Judge Levinson noted. He specifically noted that the transfer was not within the scope. And so to the extent that it was not within that scope, I would analogize it to partners in a law firm. If I'm partners with my colleagues in a law firm, we have a general partnership, we have fiduciary duties, our knowledge may be imputed. If I have a separate cow farm and one of my colleagues wants to buy a cow from me, then that knowledge would not be imputed in the context of a transfer for me selling a cow to my colleague, because that's outside the scope of that relationship. And I think
however, let's get back to the facts here. To follow up on Justice Earls' question, let's assume that we have the transfer at 5 p.m. on February 2nd. Transfer ends the joint venture. At 4:55 p.m., before the transfer has closed, isn't whatever is known to participant A in the joint venture also known to participant B?
Only if what is known is within the scope of that joint venture.
Well, let's assume hypothetically first that it was within the scope of the joint venture. Would the answer to my question be yes, if that assumption was true?
If it were within the scope of the joint venture, then the party's knowledge, if it's a joint venture that's treated as a general partnership.
And the converse would equally be true if the understanding was that if the joint venture did not encompass the subject of that knowledge, then no imputation would occur.
That's correct, Your Honor.
So the key to it is the extent of the joint venture.
That's correct, Your Honor. The extent of the joint venture and the transfer within that, whether it is within or without the joint venture.
So whatever Mr. Sellars and Stonehunt knew within the scope of the joint venture as of immediately prior to the signing of the documents involved in the closing, that information, to the extent it was within the scope of the joint venture, would be imputed to MAP.
To the extent, correct, Your Honor, to the extent that it was within the scope of that joint venture, and only to the extent that it was within that scope. Yes,
right, thank you. I'm sorry to take up so much of your time, Mr. Houston.
No, thank you for the questions, Your Honor. And so that was what I wanted to address, and I'll jump back to the beginning on the unfair and deceptive claim. The CCO hadn't really addressed that in their argument, but I do think it's worthwhile to address briefly. The lone unequivocal argument they make in advance in their opening brief, which was 1 page and 1 sentence of substantive analysis on the UDTPA claim, was a quote that says, "A fraudulent transfer is a violation of the UDTPA by the transferee." Basically saying, per se, if you have an avoidable transfer, then it's unfair or deceptive. And they cite 3 cases primarily in support of that. None of those actually say that, and this court has never recognized that. The first case was London Leasing. There, the court allowed a motion to amend to assert an unfair and deceptive claim in avoidable transfer case. The other 2, KRG and LJ Best, were simply cases where the court found that summary judgment was not appropriate because there were issues of fact remaining to be determined as to whether there were unfair and deceptive actions in connection with a avoidable transfer. And so CCO tries to walk back in its reply brief the big statement that avoidable transfer, a fraudulent transfer, is per se unfair and deceptive, and say it's unfair or deceptive if the defendant didn't purchase in good faith. And the problem with that argument as well, Your Honor, is that that is an attempt to flip the burden on the defendant to prove why it shouldn't be found guilty of avoidable transfer in connection with the unfair and deceptive claim. Effectively, the plaintiff's burden is to show unfair and deceptive conduct. The transferee's burden is to show good faith. Merely because the transferee doesn't show good faith doesn't mean that the plaintiff has met its burden of unfair and deceptive conduct. Effectively, the defendant's inability to prove good faith doesn't equal bad faith. It simply means that the transferee couldn't meet the burden of showing good faith. But it doesn't mean the plaintiff has met the burden of showing unfair or deceptive conduct. And so, in addition, CCO cites a few additional cases suggesting that there are statutory basis for finding per se liability. And in each of those cases, the Ejectment Act, employment context, and trade secrets, all of those cases involve active wrongdoing by the defendant, which we don't have here. So in effect, the court's never found per se liability. There is no per se liability. And because of that, the court has to look at the specific elements of an unfair and deceptive claim. We all know what those are: unfair, deceptive, inter-affecting commerce, and per se injury or approximate cause to the plaintiff. The trial court here specifically found that MAP acted in good faith, was a good faith purchaser, did not carry out any deceptive conduct, made reasonable business judgments in purchasing the property, why it purchased the property, and paid reasonably equivalent value in purchasing the property. The court noted that any bad conduct was stone hunts. That was conclusion of law 135. And so the trial court's firsthand knowledge in making those determinations is entitled to deference in this case, where it's determining whether there was good faith, what facts supported it, and what the subjective intent of MAP was. And I do want to note that this unfair and deceptive claim is exclusively as to MAP 2. MAP 2 was not the ultimate transferee in this case. MAP 2 simply entered into the contract. MAP Holdings was the ultimate transferee of the property in this case. And so with that, Your Honor, I've addressed why there can be no imputed fraud, and for those reasons, there also can be no imputed unfair and deceptive conduct. There was no actual unfair and deceptive conduct. And so for those reasons, Your Honors, I would simply ask the court to affirm the Court of Appeals and finding that the trial court did not err, and affirm both courts. Thank you, Your Honor.
Thank you, counsel. Rebuttal.
Mike Servin, Justice Earl. I'm assuming that you can hear me. Am I off mute?
I can now. I couldn't initially.
Thank you. Thank you. The points raised by Justice Ervin and Justice Earls are very important about the scope of the joint venture. There is, to answer the question, there is no finding of fact that limits the scope of the joint venture to simply a rezoning. The findings of fact that Justice Earls mentioned and that Justice Ervin mentioned, those are findings that there was a joint venture to develop Baxter Place. The scope of the knowledge, well, you have to also understand that there was an actual agreement between MAP and Stonehunt to conceal this transaction from CCO because they wanted to transfer the land to MAP to prevent CCO from stopping what MAP wanted to do with the development. So they entered into a joint venture to develop the property, and they concealed the transaction to further that plan of development. And so all of the knowledge of MAP up through the moment of the transfer, all the knowledge of Stonehunt up through the moment of the transfer is imputed to MAP under general agency principles. There is no limitation on the scope of the joint venture as found by the trial court. Justice Newby, to go back to the point you were asking before about the cancellation of the list pendants, I think it's important to recall that MAP has the burden under the statute to prove two things: good faith and reasonably equivalent value. Those are two separate elements. Proof of one does not prove the other. And we can't conflate these two separate elements, which is what is being suggested by MAP. And so I hope that answers your question. that has no bearing on MAP's notice of suspicious circumstances and its failure to do its duty to conduct a diligent investigation. That's a standard required by this court in numerous cases, most recently a standard followed by the Texas Supreme Court and the Fifth Circuit. That duty has to be complied with. There has to be the diligent investigation. If there's not, and there's just willful ignorance, turning a blind eye, that is not good faith, and the transferee loses, where the record shows that the transferee turned a blind eye and adopted the strategy of willful ignorance. When it comes to the unfair trade practices claim, this court has said that an unfair trade practice is one that offends established public policy, and we have a public policy of protecting innocent creditors from fraudulent transfers. We also have case law that says if it's immoral, oppressive, unethical, unscrupulous, that is an unfair trade practice. Being involved in and benefiting from your partner's fraudulent transfer is an unfair trade practice, and the court should rule as a matter of law that MAP violated the unfair trade practices statute.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.